behalf of plaintiff.
Thank you.
You're welcome.
And is Tom Pirtle on this case too?
Yes, sir. Myself, Mr. Pirtle, and Mr. Payne are all here for the plaintiffs.
Morning, Judge.
All right. Let's get started. It's a motion to compel.
Yes, Your Honor. Again, Buffy Martinez on behalf of the plaintiffs. We're picking up from where we left off on our March 6th hearing on a motion to compel. And I'm pleased to report we've definitely narrowed what remains outstanding. As of 2 p.m. yesterday, plaintiffs have 3 categories of documents that have not been produced subsequent to the court's order on March 6th. Those documents are responsive to plaintiff's RFP number 5. Those are testing documents. Plaintiff's RFP number 12. Those are adverse event files. And plaintiff's RFP number 18. Those are meeting minutes from the cross-functional safety team. And as of today, we are still missing those documents. I believe Mr. Fielding has some information. We met and conferred yesterday at 2, and I'm told there's some more information about those documents now.
Yeah, Judge, if I may, I think we're in substantial agreement with them on these documents. We had complied with our obligations to produce the documents that were the product of the custodial email search that we did on the 15th. There were some remaining objections to some remaining RFPs that Ms. Martinez had identified this weekend, and thankfully, helpfully so. We talked to her yesterday. As for those 3 categories, Judge, let me just sort of deal with them. I think we have an agreement on these things. One of the things that she'd requested was that we produced. So there were instances where there were certain adverse events that were reported to the FDA by Kimberly-Clark in connection with the recall. Ms. Martinez wanted the additional documents. So we provided the adverse reporting. Her request that we provide any documents outside of that, right? So the underlying source documents, that's fine. We've told Ms. Martinez that we're happy to do that. The only thing I would flag there, Judge, and Ms. Martinez, I sent you a text message this morning about this. I know you and I were going to try to talk, but she had hearings, so we weren't able to do that. But the only issue we see here, Judge, is that some of that information in these source files is going to contain like personal identifying information or HIPAA information, where we're going to have like our own sort of compliance obligations and duties. So our intention is to just redact that PII to the extent, or HIPAA information to the extent it exists, but otherwise produce any non-privileged documents surrounding the reporting of any of these adverse events to the FDA. So that's not an issue there. I think we have an agreement on that.
Ms. Martinez, do you have any opposition to him producing it with redaction?
I do not, Your Honor.
All right. What else? What do I need to decide then? Is there anything I need to decide right at this
point? I don't think so, Judge. We're in agreement on providing, to the extent there's meeting minutes. I mean, Ms. Martinez has pointed us to some things. If they exist, we will provide those documents. That's not an issue. The only thing I want to flag, Judge, is there's some testing documents that she's asked for. As I explained to Ms. Martinez, ordinarily I would say, sure, no problem. Like, frankly, Judge, we think these documents are useful and helpful to us. But the challenge here is as we understand it from our client, Judge, there is a a pretty significant burden that we're associated with having to manually go and identify all these things. I think Ms. Martinez has helpfully offered to narrow the scope of what it is she wants. So the only proviso that I would make, Judge, is when Ms. Martinez raised this with us yesterday in her email at 2 o'clock, we've reached out to the person at Kimberly-Clark that's in charge of, that will have to do that work to confirm how quickly that process can happen. Ms. Martinez understandably wants these documents before Friday because we're scheduled to take depositions the following week. And so we still have not yet heard back from our contact at Kimberly-Clark that will give us information about that burden issue. Our expectation, Judge, is that we can produce those documents by Friday. We don't have any reason to think that we can, but I wanted to just flag that, because if she comes back and says those documents, I'm making this up, but are located in a file in Belize that I have to fly down to get whatever, blah, 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 right? Like that's a complication that I don't expect, but we just don't have crystal clarity on. So we have an agreement to provide those documents. That's the only asterisk that I would have. And of course, we will let Ms. Martinez know promptly as soon as we have, to the extent that there's any issues. And I, again, don't anticipate there will be in getting her these documents by Friday.
Your Honor, may I respond?
Sure.
I think there is one issue left for you to decide, and that is a drop dead date for production. I want to clarify that these testing documents are responsive to RFP number 5, which was served in July of 2023. We have now gone through countless meet and confers, 2 motions to compel, and a court order issued on March the 6th, ordering these documents to be produced. I start depositions next week. I've been waiting for these documents for 8 months. I'm willing to wait until Friday, but if I can't wait any longer than that because I need them to question the corporate witnesses. So the only thing that I would ask is, I don't know about the burden. Kimberly-Clark has known about this production for months. It sounds like they're just now starting. The company is just now starting to gather them. And if they can get them by Friday, great. But I need the court to say, to make a ruling on the date for production of all of these items, which have been outstanding for quite some time.
So remind me again, have I already ordered these documents to be produced before or not? You said there was a motion to compel.
Yes. These were all subject to the hearing on March the 6th. All 3 of these RFPs were subject to that hearing.
Judge, let me just take slight issue with what Ms. Martinez said. If you recall the hearing that we talked about, what we told Ms. Martinez is we didn't actually have any of our motion to compel heard. We dealt with this question, Judge, of the dates of the trial. And then we had indicated to Ms. Martinez that we had responded to her motion, and we had told her that part of what we were going to be doing is doing a custodial review of emails, and that we would be producing documents by the 15th based on a custodial review of emails, subject to our existing objections and things like that. That's what we committed to do. That's what the order said we would do, and that's what we did do. Now, there were these other objections outstanding that didn't get dealt with substantively in the hearing, the motion to compel hearing. And what I understood the court had directed us to do is that Ms. Martinez would get the documents we produced and then identify if there were any outstanding issues associated with a motion to compel. And that's what you set this placeholder hearing for, is to take that up. She did that on Friday. Yeah, we reached out on Friday. She identified these documents. We met and conferred about them yesterday. And that's where we are right now, Judge.
Judge, I'm going to have to respectfully disagree with Mr. Fielding. Both motions to compel were set for March 6th. The court ordered documents be produced by March 16th. The only thing that happened yesterday was I tried to be helpful to Kimberly-Clark and help them limit the scope, because there was some confusion on Kimberly-Clark's part about testing documents. I'm not sure why, but my understanding of the court's ruling on March the 6th that the documents were to be produced, both motion and these documents were covered in motion to compel number 1, which was filed on January 24th.
All right. I'm going to order these documents to be produced by this Friday. And I will just say this, Mr. Fielding, and I'm not trying to fuss with you too much about this. I don't think that you're necessarily the culprit. You kind of picked up something that had been left lying for way too long. But if you need to go to Belize, you've got a big law firm, you can send someone down there. So
I'll sign up, Judge. I'll take the heat to fly to Belize.
You'll go to Belize, maybe not to Midland, but
right.
Let's see. Right. So give me an order on this, Ms. Martinez. If you get the documents on Friday and there's a huge problem, I can set an emergency hearing on Monday if we need to. Hopefully we won't. But just let us know. Have you submitted a proposed order on this?
No, Your Honor, but I can do that right away. There were proposed orders with the first two motions that were heard on the 6th, but I could do a more refined one on these specific subjects.
Let's do one more refined one for this hearing. Say that this was heard on March, I guess, whatever our first day, March 6th and March 18th, or whatever that first date was. And that the documents are ordered to be produced by Friday. Make sure at the beginning of the order, it says that this was heard on March 18th. Share a copy of this with Mr. Fielding, or do you, Mr. Fielding, do you want to be the confer on this, or do you want?
Yeah, no, that's fine. That's fine. She can just, if Ms. Martinez will send it to me and Ms. Caritas and Ms. Levy, we can get back. We've submitted an order, Judge. There is an agreed order that's been submitted to you on the last hearing that I think is.
Have I signed it or not?
I don't believe it's been signed yet. Ms. Martinez, you guys filed that, right? The order that we approved?
I'm sorry, Mr. Fielding. I don't recall. I guess I'll have to look at my notes. I don't recall that.
Ms. Caritas, do you know? Was it submitted?
Yeah, we submitted the scheduling order, the agreed scheduling order.
Yeah.
And an order on file regarding any of the motions to compel as Mr.
Yeah. So the one thing that scheduling order had in it was the provision about us producing the custodial documents by the 15th. So that order is in front of you, Judge.
I don't see that that's been filed. Are you sure it's been filed?
Yeah, I'm sorry, not yeah. Yes, sir. We have it. I'm looking at the signed copy, and it does say that documents responsive to both motions to compel will be produced.
Okay. Get me a more refined order on this. It'll be produced by Friday. Get it to me by tomorrow. And you guys have a great rest of your day. We're going to
Thank
take
you,
a
Ron.
break.
Judge, could I